Ninette, welcome.
Thank you so much.
You made a long way to here from Hong Kong, and it is a great pleasure to have you here with your competition law knowledge and worldwide expertise and experiences so that we can reflect this to our audience here. So I will just say that competition law is not usually at the spotlight of compliance matters. So it stays 2 steps ahead or 2 steps behind, but not under the umbrella of compliance. Or there is this perception of putting competition law to a different place when looking at compliance matters as a whole. Why this happens? I mean, why this twist of perception happens? Maybe we can start with what you understand from compliance and competition compliance, and then delve into the matters that will chill the compliance managers to a little bit embrace the concept of competition law compliance, which is increasingly important nowadays throughout the world. And just give you a tip from Turkey. Turkey's competition authority is very active in the last couple of years, last 5 years, let's say. And we see a lot of decisions coming out that entails the importance of a compliance program. We see decisions where employees clumsily act during competition authority visits, and these are all reflected to competition authority decisions. And then one asks this question, I mean, what happens to that company? I mean, this is a big company, and don't they have a compliance program? Don't they have rules? But that might not be the case. So, Ninette, welcome again. And I'm giving the tour to you, but my question is that what is compliance and what is competition compliance? How do you perceive these two?
Sure. Well, first of all, thank you so much, Fevzi, for the kind invitation, and my thanks also to the conference organized for the event. It's wonderful to have quite a wide audience here. And to address your questions, I think there are several different dimensions. I won't pretend at all to be able to answer fully the question, not least because we are surrounded by very many esteemed compliance officers, professional services that provide compliance programs and service clients that way. But let me begin with a few observations, if I may. I think the first observation I'd make is that there is no one-size-fits-all with compliance programs. I think the second observation I'd make is that compliance is becoming that much more important. We hear the consistent messages from regulators. You mentioned Turkey, for example. Consistently, regulators saying there is heightened enforcement. And in preparation for this fireside discussion, one of the things I did was to actually look at what various competition agencies had said. I think thirdly and critically, which I think is relatively new in the past few years, is that compliance, whether it's antitrust compliance, whether it's compliance around corruption issues, bribery issues, whether it's compliance around data issues, what is clear is that corporates today are being required by their shareholders, by society, to ensure that they are good corporate citizens. See this as part of the wider focus on governance, the G in ESG. And so I think for companies, it's just the ethical thing to do. Of course, companies are being incentivized because of the increased levels of fines, the increased in sanctions, and the heightened scrutiny. But fundamentally, it is the thing to do, and we're seeing this right across different disciplines. So I see antitrust, frankly, as just one part and parcel component of a company's overall drive to ensure a compliant culture that employees comply with competition rules, as well as all other rules that are mandated by a government, by an authority.
I will take it from here because, you know, my introductory remarks were outlining the fact that competition law compliance is seen as a separate issue when the compliance managers, the whole tasks are considered. So this might lead to subcontracting the competition law risks to competition specialists, competition lawyers, competition advisors from outside the firm or within. So the responsibility or the robustness of the compliance program is somehow may not be 100% at the hands of the compliance director. So this is, I think, number one risk in embracing, as you said, as you underlined. You said labor. We have this in, I mean, United States has its own labor issues in competition law, but in Turkey, we have seen many companies having robust compliance programs, competition compliance programs, but HR departments not knowing that what they are doing was related to competition law. This is that was significant, and this was the in 2024 was the year of labor infringements in competition law in Turkey. So thank you very much. You spotted that, and then I think one of the challenges, we will talk about that maybe if we have time, but HR departments is a human factor, as it says, but we have new technologies. So we see the competition authorities, including Turkey's authority, investing a lot on technology. So what happens? I mean, you have a compliance program, and one morning the competition authority knocks at your door, and then I think, up to me, the most important part of the process is consumed within a couple of hours, or maybe a day or two. But what sees there, I mean, as a document, as emails, as WhatsApp messages with competitors or internally, describes a little bit where this case will go, or whether you will be subject to a full-fledged investigation, and after that, with all these evidences, let's say, whether this will end up with a fine or not. So, and I knew that we had a compliance program, but what happened during the dawn raid? So how about managing the stress or employees' initiatives? This is something that, I mean, did you witness something like that before?
Well, you know, it just reminds me of a case. It wasn't my case as such, but a colleague who went to do a mock dawn raid and also audits to follow, and arrived at the premises, and literally a few hours later, there was a real dawn raid.
The real dawn raid.
The real dawn raid, because the authorities actually came to the company's premises to conduct the dawn raid. You know, I think the key is just to remind employees not to panic, and which is why I mentioned that story partly just to make the point that it's also helpful to have mock dawn raids, to refresh people's knowledge and understanding of what to do when somebody comes to knock at the door. What information is being produced. An authority won't thank you for not being fully transparent, but I think your client as well won't thank you for going to see the authority if you do not have sufficient evidence to make the case and to ensure that you can get a reduction of a penalty or immunity, which is what a company would really want.
Excellent. A couple of weeks ago, I see that we have a couple of minutes before just we go to the wrap-up. I've been in a meeting 2-3 weeks ago with Maria Jasper, the head of cartel in the EU Commission, with a few circle of, I mean, from the business associations. So his remarkable conclusion on this WhatsApp deletion case, you remember that there has been a huge fine imposed on a company whose employee deleted a WhatsApp message during the dawn raid. She said, I don't care about the message. I don't care about the content, whether it is illegal or not. I care about how the company suffered to help me to reload this message. And then I have seen this. businesses, just give me the fair opportunity to recognize your compliance program. So it's up to us to convince the authorities that we have a robust and honest compliance program. So to wrap up, I mean, we have plenty of compliance managers here. What will be your key advices, and what will be their key takeaway from this?
Also, another very good question. I think one of the keys that I've seen in my 20+ years of experience working with corporates is that compliance is a living mechanism. It's living in terms of the rules, the policies you have in place, and it's living because risks do change over time. The extent to which a regulator is focusing on a particular issue does change over time. And so it's important to ensure that your program that you have in place really is fit for purpose. That means, I think, regularly conducting spot checks, internal reviews, sending emails to employees, checking up on them, ensuring that there is that tone from the top, and the company is actually ensuring that the employees are being transparent. I think the last thing I would mention, of course there are many, many other things, but the last point I'd mention, because I'm conscious of time, it's important that we as compliance professionals remain open to the business. Open in the sense that they can come to us, they can come to you with any issue, and that you work with the employee that has done some wrongdoing to ensure that the company is fully compliant, because the interests will be different. The employee and also the companies. Obviously, your primary responsibility is to the corporation, is to the company, but it's important that you have an open and transparent culture that will enable employees to come forward as well, to raise issues, even if there isn't a direct wrongdoing, but to raise issues that they can come and discuss with you. So these are just a few thoughts that I would offer in conclusion.